15 minutes.
Yes. Well, Lord, three reasons why, good reasons, I hope, why reputation is not part of Article 8. Firstly, it was deliberately omitted from Article 8 by the framers of the European Convention. Secondly, that's the first reason. Secondly, because the ordinary meaning of words, reputation, the public esteem in which a person is held, is the very opposite of privacy, the right to be left alone, keep intimate secrets and confidences, to expect privacy. Thirdly, because that is the application in the most recent case in the European Court, which has explained why reputation issues must be dealt with under Article 10 rather than Article 8. Your Lordships, I think, have separately an article by Professor Ballou about the European Convention on Human Rights and the right to respect for private life, which is...
My copy finishes at page 19.
Yes, it is from a book published in 1973 by Professor A.H. Robertson.
Yes,
and
like that.
It is...
Yes, I have got that, yes.
19 just seems rather eccentric phrase to finish, doesn't it?
I'm sorry, we haven't put the frontispiece on it, but this is an essay in Professor Robertson's book, which is set out, paragraph 21 gives the full citation, but at page 14 you see halfway down origins of Article 8 of the Convention sources. It's obvious that Article 8 was to a great extent inspired by Article 12 of the Universal Declaration, which includes honour and reputation. It is at once clear, in spite of obvious affinities, the two texts contain a number of differences. The first difference, Article 12 of the Declaration, unlike Article 8 of the Convention, expressly forbids attacks upon honour and reputation. And then at the bottom of page 15, the last paragraph, it should be observed that the words "nor to attacks upon his honour and reputation" in Article 12 were left out of the text proposed by the Assembly. This omission was certainly intentional. In the report, it has always been understood that in referring to one or other article of the Declaration, the resolutions adopted by the Committee did not mean to refer to all the provisions, but only to those specifying the content of the freedom provided for in this resolution. The Assembly thus deliberately limited the proposed safeguard to the right to respect for private and family life, the home and correspondence, excluding protection for honour and reputation. And then halfway down, after the quote, the reference in Article 12 of the Declaration to the protection of honour and reputation was again deliberately omitted. The experts' report states, in accordance with the Assembly's intention, only a certain part of the rights mentioned in Article 12 and 16 were included in the Convention. And so, on the Travaux Preparatoires, that was a deliberate omission. And one can understand, in principle, why that omission should be, because privacy is a state where one's not watched or disturbed by others. Reputation is the right to public esteem, the right not to have one's public reputation tarnished. When, I know Lord Hope in the BBC case, picking up from, I think, Lord Hoffman, refers to the immortal part, the Othello reference. But of course it is an immortal part because it's public, because it's there in the obituaries, and Cassio in the time was publicly shamed by being found to be drunk on duty. It is the immortal part precisely because it is public. And that distinction is clarified in the most recent case, and I fully concede that some decisions of the European Court seem to indicate that reputation is part of Article 8, some don't. And the bull was taken by the horns in the most recent case that's in the little bundle that was handed up this morning, Caraco and Hungary. Caraco and Hungary, which is in the bundle with the Human Rights Act. And this was a case where at page 3, the facts don't matter, at page 3, paragraph 12, the applicant complained that the authorities failed to protect his rights under Article 8, as they didn't pursue criminal libel proceedings against a political opponent who had defamed him. And then it sets out Article 8, and the court at 17, over the page, the court's assessment. The court is satisfied that the purported conflict between Articles 8 and 10 of the Convention in matters of protection of reputation is one of appearance only. To hold otherwise would result in a situation where the outcome of the court's scrutiny would be determined by whichever of the supposed competing provisions was invoked by the applicant. In the instant case, the applicant submitted that by refusing to prosecute his opponent for ruining his reputation, the Hungarian authorities had failed to protect his right to private life as defined by Article 8. For the court, this claim implies the right to reputation is an independent right, protected by Article 8 of the Convention, which the state has a positive obligation to protect. And then over the page at 20, in regard to cases in which a violation of the rights guaranteed in Article 8 is asserted, the court points out that the protection granted by the state should be understood, and the alleged interference with those rights originates in an expression. The court points out that the protection granted by the state should be understood as one taking into consideration its obligations under Article 10. It is the latter provision which has been specifically designed by the drafters to provide guidance concerning freedom of speech. In addressing the problem, the court reiterates that private life includes personal identity, and further observes that in the von Hanover judgment, it extends protection of private life to the protection of personal integrity from a broad interpretation of Article 8. Concerning the question at 22 of whether the notion of private life should be extended to include reputation as well, the court notes that references in von Hanover reflect a clear distinction, ubiquitous in the private and constitutional law of several member states, between personal integrity on the one hand and reputation on the other, the two being protected in different legal ways. The reputation has traditionally been protected by the law of defamation. For the court, personal integrity rights falling within the ambit of Article 8 are unrelated to the external evaluation of the individual, whereas in matters of reputation, that evaluation is decisive. One may lose the esteem of society, perhaps rightly so, but not one's integrity, which remains inalienable. So, and then at 24 and 25, which we've set out in our at paragraph 23, the court reiterates that 10.2 recognises freedom of speech may be restricted.
Which paragraph?
Paragraph 24 of Caraco. The court reiterates that 10.2 recognises freedom of speech may be restricted in order to protect reputation. In other words, the Convention itself announces that restriction on freedom of expression are to be determined within the framework of Article 10 enshrining freedom of speech. The Court is therefore satisfied that the inherent logic of Article 10, that is to say, the special rule contained in its second paragraph, precludes the possibility of conflict with Article 8. In the Court's view, the expression "the rights of others" in the latter provision encompasses the right to personal integrity and serves as a ground for limitation of freedom of expression insofar as the interference designed to protect private life is proportionate. So, my Lord, building on that distinction, we would urge, and we do at paragraph 23 of our case, it follows that the right to reputation may override the right to free speech where it is necessary to protect or vindicate it in a democratic society. Interferences with free speech based on the right to reputation fall to be judged under Article 10 and do not engage Article 8. And that goes on to cite Caraco. And then under the rubric Res Reconsidered, the decision in Caraco in the scheme of the Convention demonstrates that the intimate personal information that merits Article 8 protection from invasion must be carefully separated from the right to public esteem referred to in 10.2, which may override freedom of expression. Ries was a case where it was sought to prevent identification of a defendant in a murder trial to protect her child's mental health, family, and personal development. These were integrity rights. And then we do note that there was no argument about the point of res is at tab 4 in the appellant's cases, and at page 596 at the bottom, in the course of counsel's argument, Lord Bingham puts it to counsel at H, given the court's duty to uphold convention rights, the appeal turns on the balancing exercise involved. And that was simply accepted by counsel. That's at 596 at H. And then in
But there wasn't any question in res that Article 8 was engaged, no, because this involved the family life of a child.
It involved the psychological...
and in particular, the substance of that child's relationships with his mother in particular, but also his father.
That's right.
So it's unquestionably an Article 8 case.
Yes, yes, we accept that. But we say that the problem of, at 596 at H, that balancing exercise, it seemed to be put as though this is the approach in all cases. And in Lord Staines's speech, having at page 602, at the bottom, having said that there was, under the ECHR, there is a general and strong rule, and indicating that it's the same as the common law. Well, we say it's not, because Article 6 is far wider than the common law, allowing interferences to protect morals and so forth. It then, at the bottom of page 605, at paragraph 23, the House unanimously takes the view that since the 1998 Act came into force, the earlier case law about the existence and scope of the inherent jurisdiction need not be considered. The foundation is now derived from conventional rights. This is a simple and direct way to approach such cases. The old law may remain of some interest in regard to the ultimate balancing exercise. My noble friend Lord Bingham invited the responsive counsel to this approach, both expressed agreement with it, and then went on to talk about the new methodology. My lords, on behalf of the media, we say that the new methodology, the parallel analysis, is impossibly complicated for such a decision to be taken in magistrates' courts, in county courts. It involves a very complicated exercise, which is very different and to the exercise that had hitherto been conducted, namely, is this restriction required in the interests of justice? And so, of course, Lord Steyne went on to say at 29 to talk about, quote, K.M. Todner and the importance of the freedom of the press to report criminal trials, and then at the bottom at H, having Lady Hale's comments were not accepted, and 4 lines from the bottom, the glare of contemporaneous publicity ensures trials are properly conducted. And then over the page, at 32, consequences of the grant of the proposed injunction, he sets out the specific consequences which we, the media, say, and Mr. Dodd's statement and the statement from the Times and The Economist picks this up, that the balancing act that Ries lays down has had precisely these consequences, that parties now are using claims of Article 8 to avoid damaging publicity as the result of a trial. And at C to D, this would confront newspapers with an ever wider spectrum of potentially costly proceedings, which would seriously inhibit the freedom of the press to report criminal trials. At E, the last 2 lines of paragraph 33, the process of piling exception upon exception. At E, the danger of disembodied reports, informed debate about criminal justice will suffer. 35, newspapers can't always contest an injunction, it's a costly matter. And G, the particular problems of local and regional newspapers, and over the page at 609, the impact of new development on the regional and local press strongly militates against its adoption. We say that these dangers have come to pass by virtue of the Ries test, that every case is a balancing exercise and a proportional, I think it's the exegesis that Mr. Tomlinson in paragraph 14 of the Appellant's case sets out, has to be gone through, and this has become a nightmare for, and has led to an increase in pseudonym orders. We say that the simple way to reclaim the position and to prevent the pillar of open justice being eroded is to exclude from Article 8 claims those like this one that are based on reputational damage.
Thank you very much indeed.
So that is our...
My lords, my lady, may I make 3 points, each of which applies only to A, K and M. I don't intend to say anything about H, A, Y's case beyond the short points that are set out in the skeleton argument. The first point concerns the restrictions that apply to the directions in place for A, K and M under the terrorism order. As the court is aware, under Article 5 of the terrorism order, the Treasury has a power, when it makes a direction, to inform only certain persons of that direction rather than to publicise the existence of the direction generally. Where the Treasury exercises that power to inform only certain persons, it may in addition specify in the direction that certain information contained in it is to be treated as confidential. Now, in relation to A, K and M, the information that was to be treated as specified to be confidential information was their identity. For your note, in the appendix relating to A, K and M's case, you see the direction that was given in August 2007 at page 240. But the information was as to the identity. Clearly, the effect of Article 6.3 of the terrorism order is such that if this court required the identities of A, K and M to be made public, publication of that information would be lawful and would not amount to an offence under Article 6 of the terrorism order. May I just pick up on one point, however, suggested...
you say required that the identity is made public. Isn't it truer to say didn't require them to be to remain or to be confidential? I suppose it depends where you're starting.
Well, my lord, it does, and I use that language because that is the language used in Article 6.3d, which identifies as a lawful disclosure required under the rules of court or a court order for the purposes of legal proceedings of any description.
It's rather odd phraseology.
Perhaps it is, my lord, perhaps it is, but that is the phraseology nevertheless, and in terms of the order, that is where the order draws the line between a lawful disclosure of information identified as confidential and an unlawful disclosure.
If this court refuses to forbid the publication of the identity, does that satisfy the terms of provision?
On the strict reading of Article 6.3, I think the answer to that has to be no, my lord. I think that's right. And I'm taking you to this, or making this point, simply because the restrictions that apply to the directions under the 2006 order, the directions that are presently in force in relation to A, K and M, those restrictions are still in force. The letter of the 7th of October from the Treasury Solicitor indicated in the context of the process that is going on to consider whether directions under the 2009 order should be made in substitution for the 2006 order directions. In the course of that process, a decision has been taken based on advice received that the Treasury would not seek to place any restriction on any new order that is made. Now, as I said at the substantive hearing of this appeal, if a new order is made under the 2009 order, the 2006 directions will be revoked. If no order is made, no direction is made under the 2009 order, the 2006 directions will also be revoked. The Secretary of State's intention, the Treasury's intention is still that a decision either way in respect of a direction under the 2009 order will be taken by the end of next week. That is his intention. But for the present, the 2006 directions remain in force, and they are subject to that restriction relating to the identity of the persons concerned, A, K, and M, being confidential.
So the Secretary of State decides yea or nay will be restrictions by reference to the police.
And also information, for example, from the security service. There may be other sources of information from case to case.
But so what's he getting information about? I mean, what's the touchstone?
My Lord, I'm not able to talk in specifics in relation to these three cases, but in general, for example, one could hypothesize, say that the police were in the course of conducting an investigation, that there might be a reason on that basis for them to recommend that the fact that the direction had been made should not be generally publicised, but should be communicated only to a more limited group of persons. Clearly, from the Secretary of State's perspective, there is a balance to be struck, because ordinarily, economic sanctions of this type will work best when the fact that they are in place is publicly known.
Yeah, exactly.
And to that extent, there is a distinction between what works best in order to give effect to economic sanctions and what might work best to give best effect, for example, to a control order.
I mean, if we're being asked to take account whether or not there are restrictions on the, who knows about the designation, I mean, we ought to know, what are the yardsticks whereby he decides these things, and if he's advised by me, what are the considerations in their mind? I mean, are they the same considerations as we ought to be having, or are they different?
Well, the position obviously has moved on, certainly since the directions, the latest directions were made in 2008. The present position is as set out in the Treasury Solicitor's letter of the 7th of October, that the considerations that in 2008 caused the Treasury to place restrictions on the publication of the direction, they no longer apply. And
we don't know why.
Why they no longer apply?
Absolutely. I mean, should the Court of Appeal have paid heed to them when they continued this order? Should Mr. Collins have paid heed to them? I mean, unless we know on what basis they're made. I mean, how are they meant to affect the Court's decision as to whether to allow the names to be published or not?
Well, my Lord, I would suggest that they will plainly be relevant to a Court's decision on this point.
But why?
Because they may well indicate a public interest that weighs in favour of a restricted
Well, we don't know what it
publication.
is.
Well, my Lord, the point didn't arise either before Mr. Justice Collins or before the Court of Appeal. But if an explanation had been required, an explanation somehow would have been provided. But the position now in relation to A, K, and M is that those reasons that favoured the restriction are no longer reasons that apply. And hence the position that has been adopted in relation to any direction that may be made under the 2009 order.
All right, but then the next time round there'll be a chap and he will have restrictions. So what's the Court to do? Is it slavishly to follow that and say, right, the Secretary of State, on advice from the police and security service, for reasons completely unknown to us, has decided to restrict publication, and therefore we do too? I mean, what's the Court to do about it if it doesn't know on what basis?
Well, I gave you an example of a situation where a restriction might be put in place because it was considered that absent the restriction there might be prejudice to an ongoing police investigation. I gave you that as an example. Well,
I'm not sure I can actually understand it. I don't know. I mean, how does it work? How does it prejudice an ongoing police investigation?
I'm sorry, but I was simply giving you an example.
I know, but I can't understand the example. How does
If they know we're on to A, they may therefore think we're on to B.
Precisely. That
That's the point,
must be a
isn't it?
scenario, yes. Yes, that must be a potential scenario. So, my lord, in those situations, that information would need to be communicated to the court in a way, of course, that did not itself cause the prejudice to the public interest that the restriction is designed to prevent.
How does it work in practice? The court then has to be told in confidence.
Yeah, if that situation...
We don't, please, the names must not be made public because A, B and C.
My lord, yes, that would be the situation that would prevail, yes.
Yes, I see.
The final point I wanted to make in relation to Article 6 was simply this. My lord, Lord Phillips considered this morning the possibility of someone knowing the identity of a person whose identity was to remain confidential because of such a restriction from an entirely different source, and what would be the position of that person? Could I just draw to your attention Article 6.2? I'll read it to you in case you don't have it to hand. It says, a person who obtains information which is to be treated as confidential in accordance with paragraph 1, or to whom such information is provided, must not disclose it except with lawful authority. So one sees that Article 6.2 is a very wide prohibition on publication, regardless of the specific source by which the person has come to know about the confidential information. I should also draw to your attention paragraph 6 of Article 6, which says that in proceedings for an offence under this article, it is a defence for a person to show that he did not know and had no reasonable cause to suspect that he was disclosing confidential information. And so one sees the balance being struck by the existence of that defence. My lord, that was the first point I wished.
I just want to follow this through.
Yes.
Direction is given, coupled with a direction, this information is to be treated as confidential.
Yes, the information to be confidential would itself be specified particularly.
Yes, that is specified to the persons to whom the information is disclosed.
Yes, my lord.
There are then proceedings such as these.
Yes.
And in the proceeding, despite the proceedings, anyone who learns in the course of the proceedings, say, the confidential information, is obliged by the terms of the order not to disclose it, unless there's lawful authority, and the court can give the lawful authority, can it, if it chooses, in its discretion.
Yes, my lord. Yes, it may. Yes.
So who's going to raise the issue? The media?
The media...
Or anybody else who wants to disclose it?
Yes. Yes.
And if they don't, the court should have its own motion if it considers the confidentiality order unjustified. It can't even approach the question unless you have this process under which it's told why the confidentiality order has been made.
Well, my lord, when matters came before, assume matters coming before the court, proceedings would be issued by the person who is subject to the direction. Presumably that person, at the time proceedings were issued, either would seek some form of order protecting his identity or would not. Just a starting point. Assume no order was sought by that person. If there was if the direction itself specified information that was to be confidential, and that information was the identity of the person concerned, it might be something else, but assume it was that. Now, in those circumstances, one could expect that the Treasury itself, in connection with those proceedings, would apply for an order anonymising the person in relation to the proceedings. And on that application, the Treasury itself would need to explain to the court why it was actually seeking that order in the proceedings.
Well, on your argument, when this was raised before Mr. Justice Collins, the response of the Treasury should be, well, actually there's no need to make the anonymity order because unless you authorise disclosure of the name, it will already be unlawful for anyone who's discovered this information to disclose it. that's your position, isn't it?
Well-
Unless Mr. Justice Collins had actually made a positive order rendering it lawful to disclose the names, the order that the Treasury had made
As things,
rendered it unlawful to do
as
so.
things stood in the wake of Mr. Justice Collins' judgment,
Yes.
the answer to that question is no, because he'd quashed the order, not just the direction.
Yes,
He'd
yes.
quashed the order.
Yes.
And assume he'd made some other order that hadn't had that effect on the
Yes,
terrorism
yes.
order. Well, in those circumstances, strictly speaking, as a matter of logic, one might say, well, then it's just unnecessary. But clearly, as a matter of prudence in those circumstances, and in order to ensure that people who were present at the proceedings and were reporting the proceedings were aware of the restriction that existed, clearly it would be sensible in those circumstances to seek an order from the court based on the same considerations that had caused the restriction to be put on the direction itself.
Well,
We're potentially getting into the same issues as in the main appeal, aren't we? Because you're telling us that subsidiary legislation has been used to make a huge hole in the principle of open justice.
Well, my lord, no, I wasn't intending to tell you that. Nor was I intending to
Does
conceal
it not
that.
follow?
But my lord, the point I was making, the only point I was making was simply to draw to your attention the effect, firstly, the effect of the restriction on the directions that are presently in place, simply so that you had that in mind when considering the submissions that you've heard from Mr. Robertson and those you will hear from Mr. Tomlinson.
But it's a little odd, isn't it? At the end of the hearing before Mr. Justice Collins, the issue of anonymity was then raised.
Yes.
And the applicant, the individuals wanted anonymity for their own reasons.
Yes.
And the Treasury didn't say yes, and we support that because we've also got quite independently very good reasons for anonymity. Please, and we're going to appeal, and we want the anonymity preserved, instead of which they simply took a neutral stance. We've got nothing to say.
Yes. I can't now recall on my feet whether the transcript indicates a neutral stance or simply it was said that there was agreement. But one way or the other, yes, I fully accept that point, my lord. But in the circumstances that prevailed on that day, clearly it was not a point. In the nature of hearings, sometimes all points don't get fully ventilated. It's not because anyone has forgotten anything or anyone is doing anything incorrect. It's simply the nature of those hearings that one has when judgments are handed down.
I mean, Article 6 doesn't prevent the individual from telling his solicitor, does it? I mean, he wants to challenge the direction. What is the position? I mean, how can, on one reading, I suppose he's so restricted by it he can't take any proceedings against the direction. But you don't take that point.
No, I don't take that point. I couldn't. If one looks at Article 6.3, which identifies what are lawful disclosures, that includes disclosures with the consent of the person who is the subject of the information.
I see.
So in that
Yes.
situation, it wouldn't provide an
Can
indication.
Right.
Can I just ask this? I mean, when the Secretary of State, having taken advice from these people, decides to make a restriction order, I mean, does he take account of the fact that this might go to court, in which case there then becomes another dimension to the whole thing, namely the principle of open justice?
Yes.
I mean, does he take account of that when he's making his restricted designation?
My lord, no, because it's not inevitable that there will be court proceedings.
No, but it's possible.
Yes.
So
But if there were if such proceedings do follow, clearly that is something that would be a matter within the purview of the court. Because clearly the question of anonymity, assuming, and again we have to assume for the purposes of this argument, that the information identified as confidential information is the identity of the person, assuming that to be right, well that is something that would need to be taken up with the court, one way or the other, and the court would need to form a view. And clearly the court itself would have well in mind the principle of open justice.
So it would take a more exacting view of the matter than the Secretary of State when making his original designation?
No, not more exacting. It would take a view, however, that would take into account further and different public interests which arose on the occasion of the court proceedings. The principle of open justice does not arise as a public interest for protection until there are in fact proceedings.
Well, you've made the point that since Mr. Justice Collins quashed the order, then the question of the effect of the direction didn't arise. But let's take the scenario at the beginning of proceedings, and an applicant applies to the court for an anonymity order.
Yes.
Could he simply say, well, I don't have to make this application because I can rely on the terms of the direction, and it's up to the press to try to persuade the court that they should make a positive order requiring the publication of the information?
I would prefer to address that question by reference to the position of the Treasury, because in that situation, the Treasury would have a specific interest in seeking an order, say, for anonymity in the proceedings, in order to preserve the position that it regarded as appropriate when making the restriction on the direction. So in that scenario, my lord, I'd suggest that actually it would be the Treasury who would raise the matter with the court.
Well, is that right? I mean, the effect of the order is to create a criminal offence on the part of anyone who discloses the information.
Indeed.
Does it need to apply to the court at all?
Again, my lord, strictly speaking, perhaps it does not, but simply as a matter of common sense and prudence, one would expect the matter to be aired before the court, as really follows from the point made by my Lord Simon Brown. When the Treasury are considering whether or not to restrict the direction and what to identify as the confidential information, it will have regard to a particular set of interests, the interests that are before it. Should the matter get before a court, one sees other interests coming into play as well, the interest in open justice.
But it is quite important in terms of the incidence of the burden of proof, because an applicant for an anonymity order assumes a burden of persuading the court that the order should be made, whereas arguably, at least, if the applicant can rely on the terms of the direction, then it would be for the media to persuade the court on material that it would produce that what I've described as the positive order should be made. But of more concern to me is the tension that this introduces between the principle of open justice, which is something which falls within the purview of the court, and the effect of the order on that, preemptively, the preemptive effect of the order on the principle of open justice.
Well, 2 points, if I may. Firstly, the decision to identify certain information as confidential information, to bring it within the protection of Article 6, is itself a decision that is capable of challenge before the courts. In terms of the, as it were, preemptive effect on the principle of open justice, I would suggest that there is no preemptive effect. Clearly, when a matter comes before the court, assuming there is a restriction in place, firstly, that restriction may itself have no impact at all on the conduct or reporting of the court proceedings. If it does, it is a matter that the court, one would expect, would be drawn to the attention of the court by the Treasury, and one would expect in those circumstances the court to deal with it based on, as I say, an explanation to it of the reasons for the restriction, provided to the court in a way which, of course, did not itself harm the public interests that the restriction was designed to protect. My second point I can deal with very briefly.
Yes.
My Lord, you asked in relation to A and K whether they were in receipt of benefits.
Yes.
My Lord, the position as I understand it is that they are not presently in receipt of benefits. As regards what their income is, or for that matter, where they are, those are both questions that have been addressed to their solicitors, and the solicitors have not provided an answer. So far as the Treasury is aware, well, they're certainly not in receipt of benefits. What their other income is a question that's been raised but not answered.
Yes, the clear inference is that the order is being flouted by them, because they must be living on something. Somebody must be providing with income
Presumably
for their sustenance.
That's a possibility. It also might depend on where they are.
Yes.
They may be eating in a soup kitchen, I suppose.
The families presumably are still on benefits, the wives, families, children, and so on.
I believe they are still in receipt of benefits, but the reason, well, again, not wishing to go back into the substantive hearing, the reason that the benefits payments were subject to the restrictions was the presence of the designated person in the household and the fact that the benefits were calculated by reference to the presence of that person. And clearly that's no longer the position.
I understand their wife say this is absolutely intolerable, get out. That seems to suggest it's happened.
That's what the evidence says, yes. My third point specifically concerns M, and the particular concern in relation to M, primarily of the Home Secretary, that any order made in these proceedings should not risk disclosure of the fact that M is subject to a control order. Well, in respect of the control order proceedings, there is a specific anonymity order in force. That's the order of Mr. Justice Mitting. It's in the Appellants bundle, and it is at tab 8, if you wish to see it. I don't invite you to look at it now, but that's where it is.
Tab 8 in
the Appellants bundle.
Could I just ask a general question about this? Doesn't perhaps arise directly, but when a control order is put on somebody, it involves, usually in its terms, rather severe restrictions on who's allowed to visit and what has to be done before somebody visits, and so on and so forth.
Yes.
What happens when somebody says to somebody under control order, I'd like to come and have a drink with you tomorrow evening? Is he allowed to say? Terribly sorry, you're not allowed, unless you get permission. I mean, in reality, he's going to have to tell people, isn't he?
Yes.
And so when the word get around?
Yes, to that extent, of course it must, yes.
So, I mean, is it really realistic trying to keep under wraps the fact that somebody's under control order?
Well, I was going to take you to the judgment in AY, which dealt specifically with the question of anonymity and control orders. But I was going to do that simply to make the point that in relation to control order proceedings, the courts themselves are acutely aware of whether or not anonymity should be granted, and the fact that that is a point that needs to be tested. And, my Lord, I was going to do that simply to indicate that there was good reason why any order that this court made should be consistent with the order of Mr. Justice Mitting in respect to the control order proceedings. My Lord, if I take you to that case, I hope, in part, I will answer your question, I hope. That case is, again, in the Appellants bundle. It's at tab 10. Well, before I take you to that, Mr. O'Connor, who has significant involvement in control order proceedings, makes the point to me that in practice it is actually quite striking the extent to which persons who are subject to control orders do not tell others that they are subject to control orders. And so in my Lord's example, they might just say, no, I don't want to come out, or I can't come out, or whatever. But my Lord...
is there an exception which allows the person subject to the control order to tell people? Is it the same sort of thing as it's not?
No, there's no restriction within a control order on a person saying that he is subject to a control order.
Nothing.
The only point that I make is that in practice, many of those who are subject to control orders choose not to make that matter.
Not something to be advertised, I suppose.
Yes.
And if he did tell somebody, there would be no restriction on them telling somebody else.
No, not at all. My Lord, AY itself, if I could just invite you to look at a small number of paragraphs in that. Firstly, the issue before the court, and obviously this was a contested application where Times newspapers were present and represented, concerned the granting of anonymity in a specific control order, that of AY. Paragraph 2 of the judgment of Mr. Justice Ousley, he notes there simply that there is a specific power in the Prevention of Terrorism Act and CPR 76 to permit an order to be made for anonymity of the controlled person. So one sees there a specific power above and beyond any other power the court might possess. And then at between paragraph 5 and 6, he identifies the general arguments in favour of maintaining anonymity concerning the monitoring and enforcement of a control order. If I could invite you to read paragraphs 5 to 6, please. And could I also invite you to read paragraph 8 as well? My Lord, I invited you to read paragraph 8 just so that you could see what has now become the general practice in relation to controlled orders at the time that the order is initially sought, if an application for anonymity is made. My Lord, further, paragraph 18, one sees put very shortly the position in AY's case itself, which was that the case for anonymity put forward by the Home Secretary relied on the sort of factors which underlie the generality of arguments I've outlined earlier. There are also considerations particular to this case. And then, my Lord, two important paragraphs, 23 and 26. Could I invite you to read both 23 and 26, please? My Lords, I invited you to read those paragraphs simply because they indicate the conclusion stated by Mr. Justice Ousley, which I would submit is correct, that certainly in the control order context, there are broader public interests that come into play. The existence of those interests is recognised by the express power within the Prevention of Terrorism Act to make anonymity orders in connection with proceedings, and that those more general public interest considerations related to, for example, the effective operation of the controlled order itself, are matters that explain why in controlled order cases applications for anonymity are sought, and explain why in those cases the courts are prepared to grant them. My Lord, in the present case, clearly M is subject to such an order relating to anonymity in connection with the controlled order proceedings. We say that any order that this court makes in respect of these proceedings should be consistent with that order. My Lord, three final short points. We accept that in the course of the oral submissions in the substantive hearing, the fact that M is subject to a controlled order was mentioned in the course of Mr. Owen's submissions. We also accept that in the Treasury's printed case at paragraph 35 of AKM, it was also stated that M was subject to a control order.
And now, stated in the evidence that's been placed before us for this purpose.
Well, indeed it has, my Lord, yes. Both those statements were made at a stage where, firstly, when the Court of Appeal order remained in force at the time the printed statements were made, printed cases were made, and clearly Mr. Owen's comment was made at a time where this court had provisionally made an order in relation to the position of A, K and M, albeit not G. Now, my final point is that so far as the Treasury is aware, there has been no publicity to date of the fact that M is subject to a control order. So far as we're aware, that is not something that has been reported as a result of the hearing a few weeks ago. In those circumstances, we say that if you are minded to depart from the position as per the Court of Appeal's order, you should, as a minimum, make an order that would preserve M's confidentiality as a person subject to a control order, and so consistent with the order of Mr. Justice Mitting. My Lords, unless I can assist further, those are my submissions.
It's implicit in those submissions that the Treasury considers that a quite different degree of interest or excitement will be stirred up by the publication that somebody is subject to a freezing order,
Yes.
compared to that which will be stirred up if it's known that they're subject to a control order.
Well, that is right. That is simply a matter of third-party perception.
Yeah.
And clearly there are different matters that weigh on the effectiveness of freezing orders as against control orders, as I've already mentioned. But my Lord's point is really a point of third-party perception.
Yes, thank you.
My Lord, thank you.
Yes.
Can I begin by making what seems to us an absolutely fundamental point, which has not yet been addressed in the submissions today, and it's this. I think my Lord Phillips mentioned it in the course of submissions this morning, and it's this point that the court is here dealing with a very small subset of cases, not with a criminal case where someone has the opportunity to be acquitted or convicted, but cases which proceed solely on the basis of suspicion, and cases where the persons who are subject to these orders, like the persons who are subject to control orders, are not told the case against them. So the media can't report both sides of the story because much of the evidence will be closed. They're designations which may go on indefinitely, and there are potential serious adverse consequences because, as the Treasury accept in relation to control orders, albeit not in relation to freezing orders, the public perception of people subject to such orders is that they're terrorists. We say that the Treasury position is simply not defensible. The test for whether someone is subject to an order under the terrorism order and a test for a control order is precisely the same. It's the test of reasonable suspicion of involvement in terrorism. I think in the answer to the final question from my Lord Phillips, Mr. Swift said, well, it's a matter of third-party perception. But the reality is, to say someone is subject to a freezing order over their assets because of suspicion of involvement in terrorism, or subject to a control order because of suspicion of their involvement in terrorism, it's a nice distinction which we suggest any ill-intentioned member of the public who is hostile to them is not going to make.
But do you have any practical experience behind that?
Well, but my Lord, criticism is made in relation to our evidence, that we don't have any actual evidence. And of course, the reason for that is that the anonymity orders are in force. So nobody has been publicly exposed as being subject to a freezing order. That's certainly not my clients. Well, certainly AK and M have not, the anonymity orders have been enforced from the outset.
Yeah, well, didn't we release, wasn't in the case of G?
Yes.
The information was released.
Your Lordships did. And we don't know what the position is in relation to G. G was, of course, under the slightly different regime of the Al-Qaida order.
Yes.
But my Lord, Lady, it is, we say, a fundamental point that we are not dealing, in this case, with the reporting of ordinary criminal or civil proceedings. We're dealing with a very special subset of proceedings. And I'm going to come back to it, but it's because it's important but the court to bear in mind that all the other proceedings of this type under the executive detention which led to the Belmarsh case and the control order cases and these cases up to now have all been anonymised. And they've been anonymised, we say, for very good special public policy reasons, because we're dealing with people who are effectively put by the state into a position of limbo. I don't know whether the court wishes me to say anything about the issues that were debated with Mr. Robertson at the outset on Section 12 of the Human Rights Act. It's not really... Perhaps I could just make one point. The Section 12, as I think a number of the members of the court said, plainly doesn't apply to orders of this kind. It only applies to orders which are made against someone, not an order restricting the publicity of something. And contrary to what Mr. Robertson said, there is actually no mechanism in place for informing the media generally in ordinary cases. The mechanism only extends to family cases. There's a special procedure for that, but it does not apply to any other kind of case.
But they're a special sort of order anyway.
Those-
We're not there talking about anonymising the proceedings as such. We're talking about not publicising information about this particular child.
Your ladyship is right, although, of course, there's a potential overlap. There can be broader orders.
There's a very large overlap, yes.
Yes, but the point I'm making is that if the court were to say that Section 12 notice should be given to the media in every case where an order is made anonymising proceedings, the practical consequences would be quite remarkable, because it would be necessary to serve an indefinite number of media organisations every time someone was anonymised, either a witness or a party. And we would respectfully say that the points made by my Lord Hope and Lady Hale, that in reality the practical position is to allow the order of the lower court to stand, subject, of course, to this court's continuing duty under Section 6 of the Human Rights Act to act compatibly with the Convention, and doubtless the matter needs to be reviewed at some stage to ensure that those orders are properly being made.
I think it goes further than that, does it not? Because under subsection 2 of section 12, the court is not empowered to make the order until it's satisfied that the applicant has taken all practicable steps to notify the respondent, which in Mr. Robertson's case is all of the media. So you can't get your anonymisation order until that is done, or unless you satisfy the court that there are compelling reasons why the respondent should not be notified.
Yes. Well, it's certainly not my experience that such the media are notified in respect of such orders restricting reporting. Of course, the standard case, and I think this was mentioned in debate with Mr. Robertson this morning, the standard case is where an injunction is being obtained to restrain publication by an individual or in the press. And of course, in that situation, it's exactly where Section 12 kicks in. But
I think it's clear where the battle line is drawn
yes.
as far as Section 12 is
yes,
concerned.
it's in a sense that's rather by the way in terms of my. Can I just say something briefly about the applicable legal principles? Because really, with respect to Mr. Robertson, much of the debate he was engaging in with the court and the points he was referring to have really been superseded. The position we say is absolutely plain. There's a decision of the House of Lords very recently in the BBC case where this matter was directly addressed. And the House of Lords unanimously held that the appropriate way to approach the matter was by balancing Article 8 and Article 10. The suggestion that Mr. Robertson makes that somehow magistrates up and down the land are scratching their heads is not borne out by any of his evidence, and there's nothing that we've seen which supports it, because the fundamental point is the point made by my Lord Phillips this morning, that in the vast majority of cases, in ordinary criminal cases, and indeed ordinary civil cases, the strength of the Article 10 open justice interest will be so strong that all other interests will be overborne. There's a case in your lordships, in the court's bundles, called Re Trinity Mirror. I don't think it's necessary to turn it up, but in that case, the first instance judge had made an order restricting publication because of concerns of the impact on the infant children of someone accused of, convicted of possessing indecent photographs. And what the Court of Appeal said, and it was a five-judge constitution to consider the point, what the Court of Appeal said was, well, it's inevitable in any criminal case where someone is convicted of a socially disreputable activity that their family and friends are going to suffer. But that's a necessary feature of the justice system. And the reality is that in most cases, the Article 10 interest we accept will be overwhelming. There's no need, in most cases, for magistrates to engage in subtle parallel analysis or county court judges. The problem simply doesn't arise. the evidence from the journalist that says a lot of people want anonymity is the sort of thing that journalists have been saying for decades. It may be perceived to be getting worse, but it's not the result of res and the test which is the proper test. In relation to reputation, it may be, I know the court is very familiar with this, but perhaps I should just turn up the BBC case, because the point was dealt with directly by both my Lord Brown and by Lord Hope in that case. The case is it's in my bundle, the so-called Appellants bundle at tab 11. And I know that a number of members of this court were members of that court as well, and the facts will be familiar. It was concerned an Attorney General's reference which had been anonymised some years before, and the BBC wanted to make a programme about it. And at paragraph 19 of Lord Hope deals with, we would say plainly correctly, with the width of Article 8 extending to the zone of interaction of a person with others even in a public context, and referring to a range of cases and learned works. At paragraph 22, he considering this is under the heading of whether Article 8 was engaged. My Lord Hope says that the last two sentences, his reputation, his personality, the umbrella that protects his personal safety from intrusion, will be just as inevitably damaged by it. And clear, and I should also draw attention to my Lord Brown, who again considers the balancing exercise. This is at paragraph 54. And then at paragraph 69, accepts that the Article 8 right to reputation is engaged.
Well, yes, linked in that case was the presumption of innocence. It was really that gave rise. Yes, all right.
Well,
I mean, I just wonder, whether that case, which really just slavishly followed S, if you look at paragraphs 54 and 55 and 50, yes, 54 and 55, really, we were just, so to speak, slavishly following S, because nobody, and I notice now that the same counsel who was in fact there for the BBC was in fact likewise in S. And what Mr. Robertson says is he didn't really underline the importance of the Scott and Scott line of authority. And that's how the court came to be saying in S, adopted from Campbell, page 160 at C, neither article as such has precedence and all the rest of it. Mr. Robertson says, and maybe something in this, that in a way a wrong turning has been taken, or at any rate too much emphasis has been given on the equality between Articles 8 and 10, and not enough in the context particularly of the reporting of open court proceedings to the principle of open justice.
Well, my Lord, it is of course, and we I hope have made it clear in our skeleton, we accept the obvious importance of the principle of open justice, but it is not, as I think we put it, it is not, as people used to think of Article 10, a trump card which always wins in a discussion as to whether a matter should be in open court. And it's...
So. Can I just sort of interject here? Speaking for myself, I struggled quite a lot in BBC in trying to find and satisfy myself that there was a genuine Article 8 point. And after all, that was the argument. He was claiming that he had an Article 8 interference, and indeed he was saying that trumped the Article 10 point. But you have to get over the hurdle of satisfying the court in the first instance that there's an Article 8 point. And if it is there, I don't see how the court can shrug its shoulders and say, well, we don't have to trouble with the convention, we can go back to Scott.
Well, my Lord, exactly so. And can I just, I mentioned this in my skeleton, but can I just mention it again? It's that it's just conveniently set out at paragraph 16.3 at page 14, the relevant terms of Article 6, because Article 6, of course, provides for public hearings, but it provides then for a series of exceptions. And one of those exceptions is the protection of private life. So the convention itself contains the open justice principle that sets out perhaps more in more detail than the English common law has done, the various potential exceptions to that principle within the very words of Article 6 itself. So it can't sensibly be said that it's inconsistent with the convention to restrict the publicity of proceedings for the purposes of the protection of private life. Not only is it not inconsistent, it's expressly contemplated. Could I also just say, in relation to my Lord Brown's point about Reyes, that, of course, the court went on to consider in some detail the importance of the open justice principle. And it was for that reason that, despite the fact that there was some evidence that the prosecution was going to have an adverse impact on the child, a matter which, in the Court of Appeal, concerned my Lady Hale, and she would have favoured remitting the matter back to the first instance judge for further consideration.
Well, I wanted to send it back to the criminal judge.
To the criminal judge.
Because he would be in a better position than the family judge to weigh the interests.
And Lord Phillips was part of the majority said no, that Mr. Justice Headley's approach was the correct one. But the point I'm making is this, that despite the fact that there was proper evidence of interference with private and family life, it wasn't just speculation. In that case, the court did affirm the open justice principle, but said you had to engage in the balancing exercise. And we say that that's plainly right. And that the House of Lords was plainly right to take the same view in the BBC case, and it does not give rise to practical problems, contrary to Mr. Robertson's assertions, because in practice, in the overwhelming majority of cases, it's plain what the answer is. And it's plain that in almost any criminal case, the matter must be in open court and with the parties identified. And the only cases in which the courts have derogated from that principle are cases where there have been vulnerable children, vulnerable adults involved, apart from the usual national security cases and so on. So in practice, that test doesn't give rise to practical difficulties, and we say it's entirely consistent with the convention, and in fact consistent with the position at common law. I think my Lord Phillips asked the question, what used to happen this morning, what used to happen before the convention, before the Human Rights Act, and Mr. Robertson took you to one case, to the Evesham Justice's case. The case where the position was directly considered was a case, in terms of anonymity, was a case called Ex parte Castelli, which is in tab 8 of Authorities Bundle 1. And that was a case in which it was a judicial review case involving applicants who were HIV positive and who wished to be anonymised. And Mr. Justice Latham, having considered submissions not just from the parties, but the Attorney General instructed an amicus, found that there was such a power under the court's inherent jurisdiction, but it couldn't be used simply to protect privacy or avoid embarrassment. A more cogent standard was required. He referred in the course of that judgment to some previous cases where there had been an anonymisation at common law, cases involving personal injury plaintiffs with embarrassing injuries and so forth. But there was such a power at common law, strictly construed. Whether on analysis it's any stricter than Article 8 is a difficult question. But the power certainly existed. And I would also just refer to one final case on this, that it's the healthcare worker case, which involving, it's at Authorities Bundle 2, tab 17. And it was a breach of confidence claim brought by someone who was HIV positive. And it is true to say that the case was decided after the Human Rights Act, but it wasn't decided on the basis of a res balancing act. It was decided by applying the provisions of CPR 39.2, which we refer to in our skeleton, which is a power available to this court. Paragraph 18, my Lord Phillips said the order that H's identity should not be disclosed is one that could be made under Rule 39.24, and it was accepted in that case that the order was properly made. So the position has always been that in appropriate cases, anonymisation is possible. A test of necessity in the interests of justice was applied. We say that on analysis, the reality is the position is no different in the post-Ries world, if I can put it that way. But in the post-Ries world, as it were, the analysis can, in an appropriate case, be more refined. The court can go into, in some detail, what is sometimes called an intense focus on the facts underlying the application. So, I don't, subject to anything the court says, I don't propose to go any further into the jurisdiction. It's plainly there. It's established very recently by the House of Lords in two cases. And this is, we say, an obviously appropriate case to engage in a res balancing exercise.
Insofar as the case is based on reputation, what do you say about the recent case in the Human Rights Court?
Well, put shortly, the majority of the chamber of the second section simply got it wrong. If you look at the concurring opinion, I don't know if you have it to hand, but if you look at the concurring opinion of Judge Joycean, it's pointed out
Sorry, well, this is tab 1 of this little bundle.
It's one of
Looking
the...
at Caraco, are we?
Yes, one of the many disparate bundles that the court has been given.
Sorry, but where should we be looking?
The concurring opinion is on page 8.
Yeah.
And the judge in concurring points out that the paragraph 4, the bottom of the page, whether the notion of private life should be included to cover reputation, I think the question is unnecessary. The jurisprudence of the court has clearly been developed on the point, referring to, and there's a whole host of cases. I mean, the cases under the convention are so strong that there are 2 cases, both referred to here, Pfeiffer and Petrina, where breaches of Article 8 have been found because the applicant has lost in domestic defamation proceedings. In other words, the Article 8 right to reputation has not been sufficiently protected by the domestic courts. And not only is there a right to reputation, but there's a right to provide, there's a duty, a positive obligation to provide protection for reputation in domestic law.
So I think I'm not quite got the inwardness of this dispute. I mean, why, if there is an exception relating to reputation in Article 10, does anyone bother to invoke Article 8?
Well, I'm afraid your Lordship hasn't got the inwardness of it for this reason. The distinction is made between what are sometimes called the societal interests in the second paragraph of each of the qualified rights, Article 8.2, 9.2, 10.2. Those have a certain force in the sense that if you're looking to justify an interference with Article 10, you can justify it on the basis of it's necessary in a democratic society for protection of reputation. If, on the other hand, there's another convention right in play, then the exercise is a completely different one, because then you're not balancing a societal interest against a human right, you're balancing 2 human rights against each other. And in that situation, that's exactly where you have to engage in what in the English courts has been called a parallel analysis. And it's much more difficult to justify an interference with the convention right than it is to justify an interference under 10.2. That is, if I can put it this way, the theology.
I think you might also be able to pick up the point in paragraph 23 of the main judgment, that perhaps they've gone slightly far, but they don't eliminate the possibility of reputation altogether as having something to do with private life.
Yes,
and
exactly.
if in some way you're able to show that the integrity of the private life would be affected by it.
Exactly.
But Lord, why it is important is I mean, if one takes the Pfeiffer or the Petrina case that are mentioned here, that those were cases where people had sued in the domestic courts in defamation and had lost. And the Strasbourg court said they shouldn't have lost because the domestic courts was insufficiently protecting their Convention and Article 8 rights. If it was only a societal interest under 10.2, such a claim would be impossible. There's no doubt, I mean, Mr. Robertson is right to this extent. There's absolutely no doubt that it was expressly considered whether to include reputation in the Convention, and they decided not to.
Why?
It's not entirely clear why they decided not to, but they did. All the travaux preparatoires show is that they were considering mirroring I think it's from the Universal Declaration, and then decided not to, and left it out. But the as your Lordship knows, the Strasbourg court has taken upon itself the right to imply rights which were not previously recognised as being there, and in relation to reputation, the position is, if I can put it this way, that Article 8 has come to cover relations with others. It's not just it doesn't just, many people have said Article 8 is just about the fascist jackboot at the front door. And the court have said, no, it's about the way you relate to other people. And if it's the way you relate to other people, you can see that reputation is not far away, as indeed I think Lord Hope effectively says in his paragraph 19 of the BBC case.
Well, forgive me. Does that go back basically to Marx and Belgium? This is the case about the child of unmarried parents, which is the whole beginning of its looking into relationships.
Yes.
And part of what Marx and Belgium says is there's a positive obligation to enable the child to develop relationships with other members of the family. So it's not just the inwardness of the child, it's the development of relationships, admittedly within the family.
Yes, it's been given, and your ladyship's entirely right, it goes back that far, and you get Niemitz and Germany and so on, you get a series of subsequent cases where they've effectively said private life is more than just the conventional Anglo-Saxon notion of privacy, the right to be left alone. It is about your also... The contrast is between the private and the public, and private, in the convention sense, covers anything that's not part of your public duties. It's a concept that's not entirely straightforward from the point of view of a common lawyer. But,
well, the dissenter may be right in saying this requires further exploration. Could do further thought.
There's no doubt the Grand Chamber have said a number of times that reputation is a convention right, but the House of Lords have recognised it. But I should make this clear. My case here is not primarily about reputation. It's not about that people are going to think less of A, K, and M. It's about the practical consequences of designating them as terrorists.
But they fall short of Articles 2 and 3.
Well, they fall short of Articles 2 and 3, and I made that concession advisedly, my Lord, for this reason, that the House of Lords said in Officer L that you need cogent evidence of actual threats. Now, we don't have any such evidence, but the threshold of Article 3 is high. If someone attacks you physically, then that engages Article 3. But if someone spits at you in the street or throws something at your child going to school or chases you in the street and abuses you, that doesn't engage Article 3, but it certainly engages Article 8 in terms of what the court has called the physical or psychological integrity.
I mean, do you say that Article 3 is engaged in the control order cases?
I'm so sorry,
Is Article 3 engaged in the control order cases?
Well, no, we say that the position in relation to the control order case is identical to the position in relation to the freezing cases. There's actually no rational distinction between the two. In all of them, there is a substantial and significant risk of people's ordinary life being seriously interfered with. I mean, by abuse, by people hate mail, by paparazzi, by all the things that are mentioned in the evidence. And we say, as a matter of common sense, it's all very well for Professor Wilkinson to say, well, I've looked at the newspaper cuttings and I can't find anything, therefore it doesn't exist. As a matter of common sense, if it is known in a particular area of London that a family living down the road are thought by the government to be terrorists, then it's going to produce an adverse reaction. I mean,
can you make the same point as I think is made by the Treasury, that the efficacy of the control order would be prejudiced?
Well, the efficacy of the freezing order...
Is that true of the freezing order?
Maybe. Well, I was actually going to come to this point next, so perhaps I can deal with it now. But if your Lordship takes up the court takes up the letter of the 7th of October, which is the one that is in...
Sorry, the Treasury letter, yes.
Yet another bundle. On the second page, it helpfully sets out the reasons why the Home Secretary supports applications for anonymity in control order cases. The need to protect the individual and the family from adverse media and public attention, including, at its most extreme, the possibility of vigilante action. Well, we say exactly the same in relation to a freezing order, because this is someone who's been publicly or by the state designated as a terrorist.
That's not strong enough for Article 3, the possibility of vigilante action.
My Lord, it's not.
No.
But it's strong enough for Article 8, and it's regarded by the Treasury as strong enough for anonymity, and we agree. The potential for community tensions becoming inflamed if the address of an individual suspected of terrorist-related activity is made public. Again, there could be no difference in a freezing order case. The impact of A and B on the monitoring and enforcement of the control order additional resources. Well, the monitoring of the control order is slightly different because you're trying to stop the person, as it were, going AWOL. But it's certainly someone subject to a freezing order. If there are community tensions and adverse attention and so on, it certainly has a resource implication. D, the risk that media coverage of individual suspected links may prejudice future criminal prosecution. Well, the court might think that that's a rather remote risk because of the modern approach, but it's obviously the Home Secretary thinks it's a serious risk. And then the risk that knowledge of individuals subject to control order could increase his or her status in extremist circles. Well, we don't accept that we have a status in extremist circles, but the consideration must be identical in relation to freezing orders. And we say that, and when Mr. Swift was asked the question, why is it any different? He says, well, people perceive it differently. Well, why should they? In both cases, the test is the same. Are you suspected of involvement in terrorist activities? Contrary to what Mr. Robertson said, the court will be well aware of this. The position is not in relation to freezing orders. The question is not, are you suspected of moving around terrorist money? The test in the terrorism order is whether you're suspected of involvement in terrorist activities. It's exactly the same as the control order test.
One of the things I find difficult about this whole argument is I find it difficult to know what one is meant to assume about how well the police can control matters. I mean, you know, they were told that it would require additional resources. Well, okay, so be it. I mean, what is the test? I mean, is the court meant to say, well, the police can't control these things, so we can't do what we otherwise would do if the police were actually able to police the area sufficiently? I mean, I've had difficulty with this.
Well, Lord, my very short response to that is the court should take a realistic attitude. That realistically, we know that the police can't be there 24 hours a day. If the situation described in Mr. Miller's witness statement, it's obviously right. These are individuals trying to carry on their lives in the community. They're going to the playground with their children. They're going to the school with their children. You can't have a police officer on their tail in case there's adverse reaction. The court's got to be realistic, we say. And Mrs. Pearce, in her latest witness statement, I know the court's read it, but gives a number of examples. And those are realistic examples. There are people who, if they see someone is said to be an Islamic terrorist, they want to do something about it. And it may just be abuse in the street, it may be a brick through the window, it may be shouting, spitting, it may be hate mail, but these things happen, and realistically the police are not going to be able to stop it.
But I mean, do we sort of apply? I mean, I'm just trying to understand exactly how. Do we sort of say, well, if there's any risk of this, I mean, you know, because we can't. It's very difficult, for example, to quantify the risk of vigilante action, for example. I mean, for us, it's really not very easy to do. Now, do we, in that situation, sort of say, well, if there's any risk of that, then that is something which should be decisive, or that should. I mean, how does it work?
Well, I would say this, that the court has obviously got to be satisfied that there's a significant risk. It can't just be a fanciful risk. And that's why the point on Article 3, I mean, I could say, well, there's a risk that someone will attack them physically and with a knife or something, but that's pure speculation. But the court can, we say, be satisfied that there's a realistic possibility of adverse reaction for them, and particularly their families, at a lower level, as a matter of common sense. Such things are likely.
Which the police couldn't
as a matter of common sense,
couldn't deal with.
Couldn't deal with. And that's exactly, and the Home Secretary, in reality, agrees with us, because that's exactly why he takes the view that he does in relation to control orders. Now, my lady, there's a crucial next step in the argument, because one response is to say, and I'm sure this is Mr. Robertson's response, well, that's just a necessary incident of bringing these proceedings to challenge the orders. In the same way as it's a necessary incident if a relative of mine is accused of a serious and socially abhorrent crime, I may suffer adverse public reaction. And that's very regrettable, but that happens. But the crucial next step in the argument is that we're dealing here with a unique class of case. We're dealing here with people who do not have the opportunity to know the evidence against them or to clear their names on the merits. It's not a situation where if someone is accused of being a paedophile, his family are subject to adverse reactions, but the evidence is presented in court and he's acquitted, then we know that the allegation was misconceived. Here, we don't, because there's the closed evidence and there's the indefinite nature of the orders based on suspicion. And that's exactly why we say that I mentioned it earlier, but the two Belmarsh cases in the House of Lords and one of those cases in Strasbourg were anonymised. The 4 control order cases in the House of Lords were anonymised. The cases, numerous cases at first instance in relation to control orders have been anonymised. And these cases about the freezing orders have been anonymised until now.
I mean, Mr. Craig, I'm just trying to understand that. It's when, for example, somebody's charged with a paedophile offence, I mean, you don't say when you were considering whether or not to anonymise them, if you could do that. You wouldn't say, well, in the end of the day, he may be acquitted, or he may be convicted. I mean, that says a year or 18 months to go. Before he comes on, the thing has been, the fact that he's been charged is publicised. I mean, all the damage could be done.
Well, and that's because the court, in weighing the balance, says, yes, there is potential damage to the person and his family, but on the other hand, the social value placed on the open justice principle, on open criminal proceedings, is so great that the damage to his family, to him and his family, is a price that's worth paying. And why we say it's different in this case is precisely because it's not a case where there's, I've made the point already, it's based on suspicion, the evidence is closed, there's no question of acquittal, it's an indefinite suspicion. And that's why it's different. Mr. Squires draws my attention to one of Mr. Robertson read them to the court this morning in Cain Todner. When Lord Wolfe was considering the principles that applied, one of the points he made was that when a person is prosecuted, there's a public judgment and unfounded allegations are refuted.
I know, but it may be too late. I mean, if we're talking about vigilantes, I mean, they're not going to wait around for the verdict necessarily. Well, I mean, that's the tragedy of some of these things.
My Lord, it is a potential tragedy, but that is that's a price which society has decided that the balance should go in that. But the question is whether these individuals who are not subject to potential acquittal should be treated in the same way. And put shortly, we say they should not, for the reason I've indicated. The position is that if I was coming to this court, or indeed any court, saying because of the potential adverse reaction, these proceedings should be conducted in private, the court would quite rightly say I'm sorry, the open justice principle is of such strength, whatever the adverse reaction, you cannot have your case conducted in private. And that would be right. Here, we have a minimal impairment. We have there is, of course, an impairment of the open justice principle by having anonymisation. But all these proceedings have been conducted in public. And although the distinguished journalists who've given witness statements say, well, it would hamper our reporting, as a matter of fact, they've managed to report this case very well. And it was on the front page of several of the newspapers when it was in the Court of Appeal and in the High Court. And it's not just a forensic point, but it so little occurred to them that they needed names properly to report the case, that despite reporting it for over some period, it never occurred to them to make this application until a few weeks ago. So I'm not belittling, we don't seek to belittle the idea that the press would prefer to have embodied reports. That's an important principle. Lord Steyn refers to it in Ries. But nevertheless, they've managed to report this case, and particularly the important constitutional issues that arise in it. They've managed to report this case perfectly well without publishing the names of any of the individuals. And we say that that's the balance by having anonymisation of the appellants is the right place to strike it. I've set out in my skeleton what Mr. Robertson obviously thinks is a too elaborate analysis of the position under Article 8 and Article 10. I don't propose to go through that again now. The court, I'm sure that the court has read it and has it in mind. Can I just say this in relation to Hay? A lot has been made of various media interventions on his behalf. I first saw the statement, I think probably the same time as your lordships, namely when I came into court this morning. I haven't had the opportunity to take instructions on it, but the court must proceed, of course, on the basis that it's right. I'm not in a position to say anything to the contrary. Can I just make 3 points about Hay? The first is that as 6 members of this court will know, when it comes to his classification under the Al-Qaida order, it is accepted by the Treasury now that he no longer satisfies the criteria. In other words, the United Kingdom government are trying to get him off the list. So we're not dealing with someone who is even rightly suspected of involvement in terrorism.
We are dealing with someone who's on a public list.
We're dealing with someone who's on a public list, but it's and this is my second point. It's not been, although a very large amount has been drawn to the court's attention from the press. None of those reports deal with him being the subject to freezing orders in the United Kingdom. It's, I think, mentioned in 2 reports that he's on the United Nations list. That the large majority of them are about historic matters, but the actual reports don't deal with him being subject to a freezing order.
I mean, mightn't he welcome publicity? Because presumably you would say that if there's to be a fair report of the case, it would have to say that, in fact, Her Majesty's Treasury are intent on trying to remove his designation.
Well, that might be a view he could possibly take. It's not the view on my instructions he does take. And there's a third reason for it, which I know some members of the court are very well aware of, that his wife brought proceedings in relation to the way that the order affected her. Those proceedings eventually found their way to the House of Lords and formed the subject of a reference to the Court of Justice. I understand that that matter is going to be dealt with by the Court of Justice next month. The House of Lords, I think, gave judgment in April of last year. Those proceedings concerned the way that his wife lived her life, her expenditure, and the disproportionate impact, as the court found, of the orders on the way his wife conducted her private life. If he is identified in these proceedings, it's been publicly said, not just by me now, but in the course of the substantive hearing, as I understand it, in the printed cases, that he is the husband of M, who brought the previous proceedings. That will involve identification of her.
Well, that raises the question of why she has been anonymised. And she may have been anonymised because she is the wife of him.
My understanding is this, that she was anonymised precisely because her complaints concern the detail of the adverse effect of the licensing regime under the order on her.
Well, it's a pretty thin reason, isn't it?
Well, that involved her going into some detail as to how she lived her life. She was forced to explain how her life worked because she was forced to explain in evidence why the order was having such an adverse effect on her. So she was forced to expose her private life to the court for the purposes of challenging the order, which the court, the Judicial Committee, I think unanimously expressed the view that, for their part, that they could see no proper reason for the licensing regime at all, but it was a proper case for a reference.
But if they approved of her remaining anonymous, on your argument, it was simply because of the embarrassment she would suffer if these details of her private life were related to her.
Well,
can that be a sound basis?
Well, but my lord, she again falls within what I've described as a special subcategory of case. She's a person who's not accused of a crime. She is the, as it were, the collateral damage of the Al-Qaida order. She has suffered the problem she has suffered because the order has been made against her husband in a way that's not challengeable and where the merits have not been gone into and it's potentially indefinite. So she falls within my subcategory. Of course, normally, pure embarrassment would certainly not be enough. I accept that. But anyway, the court has the points. I mean, in relation to Hay, there are those three special factors. But I do, of course, accept that there's a substantial amount relating to him which has come into the public domain in a variety of ways, under a variety of names, so it would appear. But can I just finally say this, that the position is that the Treasury position we would say is contradictory. I've already made the point that there's no sensible distinction between freezing orders and control orders. But the Treasury urged this court to make an order which has the effect of keeping M anonymous for the purposes of the control order proceedings. That is jurisdictionally rather difficult because not only has M's identity as a person subject to control order proceedings been raised in open court on the substantive appeal, it's also been raised in open court today. And it is therefore, on the face of it, a matter of public record. The court has no jurisdiction under Section 11, for example, of the Contempt of Court Act to stop that matter being published because it's not been withheld from the public. It's a matter that's in the public domain. And the court has the court's res jurisdiction, if I can put it that way, is not dependent on prior withholding, but it's difficult to see how the court could, we would say, consistently exercise that jurisdiction in relation to M's status as a controlee and not in relation to other matters. I apprehend, perhaps wrongly, that in the BBC case, my Lord Brown rather favoured the analysis that the way forward that involved making an injunction, whereas I think my Lord Hope took the view it was a matter of the court's inherent jurisdiction. It may not matter, but we would say that there's an inconsistency in relation to M's control order, and the court, if the court is going to make an order which, effectively a res type of order which prevents his control order status being publicised, it consistently ought to go across the board, and it ought to cover the position of A and K as well. I hope I've not gone over my allotted time. I think I haven't. I don't know if there's anything further on which the court would like assistance.
No, thank you.
Well, in reply, what I deal firstly with Mr. Tomlinson's bullet point, which was that this is a different kind of proceeding to a jury trial because there is no finality, because there is no jury verdict. The first response to that is, of course, that jury trials often don't end in verdicts. The hung jury, there are often no prosecution again, two hung juries, no prosecution in Scotland. I believe we have the not proven verdict, which
it is an acquittal.
is an acquittal, but it's there as not proven. But the most, there is, of course, the fact, as I think my Lord Roger pointed out, that often you have to live with allegations for 2 years before they come to trial. The other point, of course, is that it's all the more important for the public to know as much as possible about such orders because of their peculiar nature. They should be challenged by an judicial review, and of course, in this case, the order, my friend drew attention, but didn't take your lordships to the actual control order.
Yes, I think we do need to discuss it. I think.
Yes.
The actual control order issued by Justice Meeting is in the Appellant's bundle, and can I just show you tab H in relation to N, the order specifically there's nothing in this order which prevents any person from A, publishing information relating to any part of the period of the court, equal to rail, which the court was sitting in public, and did not itself make any order respecting publication. This is tab H of the Appellant bundle, and second case, the control order direction by Justice Meeting specifically provide that for the possibility that the court will not make an order.
Mr. Robson, I mean, do you say there is or isn't a material difference between control orders and these freezing orders?
We say that the control order and limiting provisions should not be made. We say that the judgment of Mr. Justice Ousley was wrong. It was a case where there was no evidence put in by the media of the kind that we have here with Professor Wilkinson and Mr. Heyman. The evidence put in by the Crown was not divulged, and the fears were entirely speculative. They were of a vigilante society. They were exactly the kind of fears that have been expressed on behalf of A.K.&M, and they are fears that are not real, we say, or not likely in relation to this case.
So there's no logical basis on which this court can say control orders routinely should attract anonymity, but asset freezing orders not.
Well, only to the extent that a freezing order is of a much less perhaps reputational problem than a control order. There may be that distinction, depending on how one reads it. Seen in the press, X is subject to a control order means that they are suspected of, in some way, being terrorists or assisting terrorists. A freezing order means that they are suspected in some way of assisting the financing of terrorism. It's a relatively fine distinction, and it may be that readers of The Economist would make it, readers of The Sun would not. But we say that the control order, the general practice of anonymizing those subject to control orders is simply wrong, and one can see the basis of it in the letter. It's apparently, it's in the Treasury Solicitor's submissions, the letter of the 7th of October on page 2 sets out the basis for the Home Secretary's practice. A, the need to protect the individual and their family from adverse media and public attention, including the possibility of vigilante action. We say that is not a proper basis on which to make an order unless there is a real threat of physical violence. We say that's a speculation about a vigilante society which is not borne out by the evidence in relation to suspected terrorists. B, the potential for community tensions to become inflamed. We say, certainly here, the evidence is that the Muslim community is not, in fact, going to ostracize suspects, but does tend to apply the principle that, of the presumption of innocence and is likely to assume that they may well have been wrongly suspected. C, the potential impact of A and B above on the monitoring and enforcement of the control order and additional resources required by the local police. Well, that is contingent upon A or B coming to pass. And we say there's no evidence in relation to M specifically. And as a general principle, there is no evidence that terrorist suspects are condemned in their own community or are physically attacked by vigilantes. D, the risk that media coverage might prejudice any future criminal prosecution. Well, the simple answer to that is that it's outside the strict liability limits. Strict liability contempt plugs in with an arrest. There has been no arrest, and the idea that media coverage of police suspicions of terrorism will prejudice a trial years to come, where the public knows that the prosecution case is that they are suspected rightly of being involved in terrorism, is simply idle, because that won't happen. The jury will be told to concentrate on the evidence. That's an idle risk. And E, the risk that knowledge that an individual is subject to a control order could increase status in extremist circles. That's entirely speculative. It cuts against the suggestion that they're going to be ostracized in Muslim circles. Of course, that's not extremist, we accept. But there is no evidence at all that the fact that you're subject to a control order is going to increase your status. And if it does draw other extremists to you, the police or MI5 are on the other end of the telephone listening to the contacts that are made. So there's hardly a problem. So we would say that the general policy in relation to anonymizing control orders is wrong, and that there is no basis here in respect to M that to imply it. As to the law, could I just say that the problem with the European Convention is that Article 6 was a lowest common denominator and failed. If Article 6 is in Volume 2 of the Civil Procedure Act at page 1231, and it is sets out what was the lowest common denominator principle in 1950, where many countries, including a number of countries in Northern Europe, closed the doors of the court, had anonymous prosecutions, and it says in Article 6.1, judgment shall be pronounced publicly, but the press and public may be excluded from all or part of the trial in the interests of morals. Although the decision of Scott and Scott was that they could never be excluded in the interests of morals. Public order or national security in a democratic society, or the interests of juveniles, or the protection of the private life of the parties required. So, my lords, we are faced with a European Convention provision a lowest common denominator which is far wider than the traditional British open justice principle. The answer, we say, so that the European Convention has not had the astonishing effect of destroying or eroding the open justice principle, may be found, first of all, in Article 53 of the Human Rights Convention. It's in the small bundle at tab 3, and it provides, it's the safeguard against having that broad power cutting down the pillar. Article 53 in tab 3 of the additional bundle, the safeguard for existing human rights. Nothing in this convention shall be construed as limiting or derogating from any of the human rights and fundamental freedoms which may be ensured under the laws of any high contracting party. And, of course, at the time of the convention and now, the common law of this particular high contracting party embodied the full-blooded open justice principle. And so Article 6 of the Convention, allowing courts to close their doors for moral purposes or for privacy interests and so on, is not, in fact, going to apply where the law in this country had assured the rights of the public via the media to have the Scott and Scott open justice test. And I've already drawn your Lordship's attention to Section 11 of the Human Rights Act, the safeguard for existing rights, which provides that we can rely upon the open justice principle as well as upon Article 10. Lord, finally, in relation to the two cases that have been cited, the first was the BBC case. That was, in our respectful submission, a fairly straightforward application of Re-S. It was the balancing exercise. It's interesting that it was, I think, the only case in the books where Scott and Scott was not cited and is not mentioned in the judgments, which perhaps is an indication of the danger of seeing Re-S as the new, as it were, as replacing or superseding Scott and Scott. It was also a case about DNA testing, which did raise a traditional privacy area of one's right to private life, the personal intimacy involved in DNA testing. I think in that case for it was sperm, but it does raise the traditional medical area of confidentiality. I'm aware, of course, my Lord, that Lord Hope made comments about reputation being within Article 20, within Article 8. We simply invite the Court to reconsider on the basis which we say reflects British law and ordinary speech, that Article 8 is concerned with private life, reputation is concerned with public life, public esteem, and the Hungarian case, my learned friend says, well, it's wrong. It is the first case to analyse the situation and to draw what we say is the correct distinction, the very reason why Article 8, reputation and honour, were excluded back in 1950. It does draw a logical and coherent distinction. The other cases that have assumed that reputation is part of privacy have not analysed the position. They've made the simple assumption. The Hungarian case is the first one to actually analyse the issue and comes in our submission to the right conclusion. Finally, if the balancing exercise that Mr. Tomlinson's submission sets out at paragraph 14 and beyond is to come into play, the public interest issues we set out in our original submissions at tab 5 at paragraph 31. And I won't repeat them now for your lordships, but you'll find them in paragraph 31 of our original submissions, and they're at tab 5, and the important democratic value of letting the public judge whether in full whether the government is abusing the powers, and our evidence for those public interest submissions from The Economist is found at tab 10, paragraphs 5 and 7, from The Times, Mr. O'Neill, at tab 11, paragraphs 5 to 9, and from The Guardian, Mr. David Lee, tab 12, paragraph 4. And so that they are in our submissions. Oh, yes, 2 housekeeping matters. Your lordships will be aware that we only got Mrs. Pearce's statement at 10 o'clock last night. We have from ex-Commander Heyman and from the senior reporter on The Times had this afternoon 2 short replies to Mrs. Pearce's statement, and they are there simply explaining what the provision is for dealing with the kind of concerns that she raises. Well, your lordships asked me at the beginning about the procedure in this court, and we have simply this approach to respectfully suggest as to procedure, that any appellant or respondent who wishes to have anonymity in the Supreme Court must apply for it, submit it at the same time as the appellant's notice, and there could be a form included in the to tick a box for anonymity. If you want anonymity, you could tick the box that could be put on the form. The court could then consider the application either on the papers or at a hearing. The media should be given notice simply by notifying the Press Association and Associated Press. There is a media room just over the way, I think it's on floor 2, that such an application is to be made. The office could simply formally notify them, and of course they would see the application. The media could then decide whether or not to contest the application. If the application has to be made ex parte, then the media should be given notice of the result if an anonymity order has been granted, and they can then decide whether to challenge it. But that would be, in our respectful submission, the simple way to deal with the procedure in this court of effectuating the promise of Rule 27.1. And, my Lord, subject to the question of costs, I don't know whether you want that dealt with now or at the end of the day.
At the end of the day.
Yes. Right.
And that won't be today. We're grateful to Council for their submissions and reserve our judgment.